throughout the Commonwealth. During their given testimony shall be heard. I'll take the Commonwealth of Massachusetts Court of Appeals to be seated.
Good morning. Welcome to the Appeals Court. I am Justice Meade. With me today on the panel are Justices Rubin and Blake. Many of you have been here before, so you know how this works. Each side gets 15 minutes. You needn't use all of your time. We've read everything. My best advice is to get right to the point as quickly as possible. We will probably take a break at some point at the halfway mark. With that, our first case is 21P844, Commonwealth versus Williams. Ms. Margison.
Good morning, and may it please the Court. My name is Jenny Margison, and I'm here on behalf of Mr. KYRONNE Williams. And today I hope to address the three issues in my brief, starting with the first issue. Typically, conduct, not the charge, is what triggers...
Can you pull that microphone closer to you? There you go.
Sorry. Typically, it's conduct, not the charge, that triggers a violation, but that's not what happened in this case. The notice that the defendant received is very clear, and it refers only to the charged conduct, that the basis for this violation was the complaint out of the Springfield District Court. That's what the notice reflects, and that's what the court entered findings on. So addressing the first issue, the court erred in allowing the probation violation proceedings to continue after the entire complaint had been null-pros.
Can I ask you a procedural question, though?
Yes.
You say that the standard of review is de novo, and the prosecution says it's abuse of discretion. So could you address that first?
Sure. So I believe that this is a situation where it's a question of law and not a question of fact. Durling does address that it is an abuse of discretion for a question of fact. In this case, addressing whether how a null-pros affects a probation violation proceeding, that itself is a question of law. For that reason, I believe that the de novo standard is appropriate under the Joyce case.
Can someone's probation be violated if they're not charged with a new crime based on underlying conduct?
They can be, but the notice needs to reflect that they're being violated for the conduct and not the charge.
This is the first time you've made this argument, isn't it, that the notice is the problem? I thought your whole point was that he couldn't be found in violation for this criminal conduct after the null pros. Now you're saying that the notice, which I don't remember, maybe I mean, I haven't read it in a little while, but when I read your brief, I thought it was a legal point you were making about what you could be held in violation of a probation condition of not violating a crime was. Now you're saying the notice in this particular case didn't, put him on adequate notice that it was the underlying conduct rather than having been charged with the crime? And have you made this argument in your brief? Because I don't remember it.
I don't believe that I flushed it out in that manner. I think that I was trying to...
You mean made it? You don't believe you made it in your brief? Flushed out in that manner?
The argument is that a null pros, a case that's been entirely null pros, when the entire underlying case is null pros, you can't move forward on a probation violation proceeding when the probation violation proceeding...
But the condition of probation isn't don't be charged with a crime. The condition of probation, as I understand it, was don't commit a crime. Do you agree with me on that?
Yes.
So I don't understand what him being charged or not charged or null prossed or not has to do with any of that. There is no probation violation. I mean, I see that the charging sheet or whatever it is, the alleged violation sheet says, violated the criminal law. That's what the allegation is. Namely, and then it says, newly charged, I can't really read these words.
It says newly charged conduct, I believe.
No, it says newly charged, does not say conduct, something forgery, misuse, documents from R&V and unlicensed. I can't tell what that word is after newly charged, but okay. Are you saying he wasn't on notice because of that?
He was
or
not.
are you saying that what he was that the violation alleged was being charged, and how could that be the violation alleged? He was not, his condition of probation was not don't be charged with something. It was don't violate the law, right?
Yes, but under the due process and Durling requires that you be placed on notice for what you're receiving, what you're being violated for.
Yes, but it says violated criminal law. Right, that's what the notice says. The X is next to violation of probation.
So the notice that the defendant received.
I'm looking at the finding. I'm sorry, I'm not looking at the notice. What page is the notice on?
Excuse
Is it in
me.
your appendix?
In reviewing my record appendix, it does appear as if I neglected to include the original.
Well, now you're
notice.
making a new argument based on something we don't have. How am I supposed to know what he had notice of if I don't have a copy of the charging document?
I would ask for permission to supplement my record appendix with just a copy of that notice that the defendant
The
received.
preliminary hearing, he was on notice that he was being violated for the
So even from the record,
false license and being operating under a suspended license, right?
yes.
So there really isn't a notice issue here at all.
Well, it says the new charge out of Springfield. The basis for this violation is
What are
the
you reading?
page 6 of the transcript.
Page
Right,
6 of the transcript.
So your argument, as I understood it, is because the charges were null prost, they can't form the basis of a probation violation.
Yes.
Okay, but you cite nothing that supports that.
So there is no case law
No,
that,
but we do have cases that say if a defendant is acquitted, that conduct can still form the basis. And we have cases where the defendant, where the charges were dismissed, and we said, and the SJC has said it can still form the basis. And we have an unpublished decision of a panel of this court that says null prost charges can form the basis of a probation violation. So what do you say in the face of all of that?
so in regards to the cases that you just mentioned, I believe that the null pros occurred after the entry of the violation itself. So which is opposite to what occurred in this case.
Why does that matter?
I think that the timing is important because of the standard that the court needs to review. At the cases at a probable cause level when it's null prost, and it hasn't gotten to the preponderance of the evidence standard. In all of the other cases, like in the...
That's what they do at the final revocation hearing. They have to prove by preponderance of the evidence that these things occurred.
Correct. But in these cases, the complaints are being extinguished prior to the violation hearing having transpired. It is what happened in this case,
It's as if he wasn't charged criminally with the conduct that formed the basis of the violation.
at the time that the violation
What was your
happened.
answer to my first question?
That those cases that,
No. My first question was, can you be violated for conduct that's not charged in a complaint or an indictment?
yes, but you need to have notice of it.
So we're back to notice. Your only argument, your only complaint about this now, as you stand before us, is the adequacy of the notice. You're not saying he couldn't have been found in violation for a null prost complaint or indeed for a criminal conduct that was never charged at all. You're saying that could happen, but not in this case because of what the charging document or the allegation of violation document said. Is that right?
No, so I'm not abandoning my original argument. I'm just trying to expand on that by saying that in addition to the fact that you can't have a situation where you move forward on a complaint that has been extinguished. And I was just clarifying that in this case, the only notice that the defendant had
I'm
was-
sorry, can you explain to me, in response to Judge Meade, you just said he doesn't have to be charged at all, criminally charged, right?
He doesn't, but he
All
typically...
right, so typically they are, of course, but let's say he isn't. Somehow the probation officer walks into a drugstore and sees the person he's supervising robbing it with a gun. And the police don't charge or don't show up or something, but he saw it. He's like, I'm going to go, and that's a violation of your probation. And so he goes and writes up a complaint, and they go into court at a revocation hearing, and by a preponderance of the evidence, it's demonstrated that the defendant has, in fact, committed that crime. You agree that a revocation would be an acceptable outcome there?
Yes, and I think that that moves into issues 2 and 3 that I have in my brief, that you would still need to present by a preponderance of the evidence with sufficient evidence that he had in fact done that. And
Okay, but now I don't understand. If that's good enough, no complaint at all, I don't see how a complaint that's then null-prost has anything to do with it. Now, we still don't, again, oh, there's a complaint, no, we null-prost it, there's no complaint anymore. Okay. There's still enough evidence, and you're saying somehow something about the complaint having existed and being null-prost, but a null-prost could mean anything. I mean, if the null-prost were a judicial finding or something, this act didn't even occur, then okay. But it could be anything. It could be it'll be hard for us to get the proof beyond a reasonable doubt. It could be one of our witnesses that we wanted to use that was the best one won't show up, so we don't know if we've got beyond a reasonable doubt. It could be we're so busy that day, or whatever, we're going to do these other criminal cases, right?
yes.
Where is the transcript, by the way? You just read from the transcript, but I don't see that.
Page,
I don't see the transcript in your appendix.
It's a separate, is it the separate, it's the preliminary hearing document you were reading from, right? Page 6?
I thought you had a copy of the transcript.
Could just be me, but I don't.
Well, I think it's the one called motion hearing. We have two, probation violation hearing and motion hearing.
That's the preliminary.
I'm sorry.
No, go ahead.
So turning to issue 2, which is, issue 3 sort of wraps into the second half of issue 2. This is a sufficiency issue, which I believe is handled under the Lattimore standard that any rational trier of fact. And in regards to the unlicensed issue, the Commonwealth says that he doesn't have a license without providing any registry documentation. The trooper testified that...
Did you see the concession that the Commonwealth filed on that?
Yes. No, the concession that they didn't...
We received this morning a concession from the Commonwealth on that point, saying that they also thought there was not sufficient evidence.
I did not receive that.
We'll ask your sister how that could have happened. All right.
So maybe you could
yeah, just-
move on to the second point.
Sorry. So moving on to the forgery misuse, they're, in this instance, saying that they have a false ID without letting the judge that had conducted the hearing see the ID. There's testimony that they located a New Jersey ID that had the operator's picture and a different name. That's from page 12 of the transcript.
And then it didn't reflect, the picture was the defendant, not the person from New Jersey.
The testimony was that he believed that the photo on the ID was Mr. Williams.
Why is that not adequate for preponderance?
So the issue is that when the trooper ran the name through CGIS, it came back with no results.
Yes, I understand that. I'm asking why. I gather your argument is maybe that wasn't a picture of the defendant. Maybe it was a picture of some third party. Maybe it was a picture of the person who had rented the car before. Maybe it was another person. We don't know who it was. Because no one put, and your sister has said in her brief that it would have been better to put the fake license in, but it wasn't. Nonetheless, the trooper testifies. The question that's asked, I don't have it right in front of me, but it's something like, was that the operator of the vehicle? And he says, I believe it was, yes. And my question is, why isn't that good enough for a preponderance of the evidence finding that it was? He didn't say it could have been anyone. He didn't say, I'm not sure. He didn't say, he said, I believe it was. Now, I understand that's a colloquial expression, but it suggests that he looked at it, thought, this is the guy. Why isn't that enough for a finding by a preponderance of the evidence, which is all that's needed here, that indeed it was the operator of the vehicle?
I think because specifically it's not just whether or not it's the defendant. The charge is that the ID itself was false or forged.
Well, we have other evidence of that. We'll get to your point, but your sister argues, opposing counsel argues that your that the fact that the RMV records were admitted without objection during the closing is good enough. If we find that's good enough, so that we know that whoever that person is, it's not Aton, whatever the person's name is on the license, and the officer says, no, it's a picture of the defendant, why isn't that good enough?
I think very specifically, when probation introduced their evidence during what would have been the closing, after evidence was closed, their evidence directly contradicts the testimony of the trooper.
Yeah, but that's not viewing the evidence in the light most favorable to the Commonwealth, though, is it? And as we measure sufficiency based on what's admitted without regard to the propriety of its admissions, so we get to count the exhibit that came in during closing.
Okay.
So, and that exhibit showed that it was not, that the defendant's picture was on there, and that did not depict the fellow from New Jersey whose name was on the license.
That CJIS inquiry did not depict an African-American gentleman. It depicted a white gentleman. That's correct.
Okay, thank you.
Thank you.
Ms. Gauthier.
Good morning. May it please the court, Stacey Gauthier for the Commonwealth. I would apologize to my sister if she did not receive the concession that the Commonwealth had filed late yesterday afternoon. We filed it by e-file, although I was not personally the person who filed it e-file. However, because it was so late in the day, I did call the number that was listed on my sister's brief and left a voicemail message just telling her that we had filed that concession. So I apologize if she didn't get it. I have another argument in the other session later. So when I came in this morning, I wasn't here long. I signed in and then I ran over there and came back, and it was just right before you came out. So I didn't speak to her.
You have a hard copy for?
Mr. Guarino.
Yeah, she can have my copy. But with regard to the first issue, it's the
Can we
Commonwealth's...
first discuss whether this is a de novo review or an abuse of discretion review?
It's the Commonwealth's position that this is an abuse of discretion.
It's not a question of law, the status of a null process as it relates to a probation violation?
We would suggest that it's the same standard
Regardless?
regardless of whether it's nil pros before the case or after the case. So it's our position that it's an abuse of discretion. If it was nil processed after the...
I'm sorry, what's an abuse of discretion? I don't understand how it could be...
The finding that there was a violation of probation.
Okay, I don't think that's Judge Blake's question or any of our questions.
Sorry.
I think what we're asking is, we're reviewing this question, can criminal conduct that has been charged and then been made the basis for a probation violation and then null prost, can the Commonwealth go ahead with the probation violation?
Yes.
And the question is, do we review that question de novo, or is it an abuse of discretion standard?
I would suggest, again, that it's an abuse of discretion.
How can it be an abuse of discretion? Either that null process, a matter of law, means you have to do something else or issue a new violation notice or never go forward on it, or it doesn't. It can't be up to the judge to decide whether to go forward unless, as a matter of law, it's permissible, right?
Correct. So if it would, so then it would be de novo. It would be a matter of law in that instance. But the factual finding of whether ultimately...
No, of course.
That's
well, a factual finding isn't reviewed for abuse of discretion. It's viewed for clear error, right?
Yes.
Okay.
Sorry. So it's the Commonwealth's position that it was proper for the Commonwealth to go forward on a probation revocation hearing on charges that had been null prost prior to the revocation hearing. It doesn't matter when the case is null prost because the liability comes not from the new charges, but it comes from the conduct that violates the probation. Thus, even conduct that's uncharged, if it's in violation of the probation, that can still be a basis of revoking the probation. So it doesn't matter what the Springfield District Attorney's Office did. The question at the hearing is whether the defendant's conduct violated his Bristol County probation. So I would suggest, it doesn't matter when the case is nil pros.
Do you have the notice of violation?
If it's not in the record appendix, Your Honor, I don't have it.
Okay, that's fine.
I apologize.
No, it's not. No, it's not in the record appendix. That's all right.
I only brought the record appendix.
If we agree with you that one of the two charges, there's insufficient evidence, we have to remand this, don't we?
Yes, you would have to remand this to the judge who heard the revocation hearing.
All right, so let's talk about the second charged crime, the fake license.
Correct.
You agree that you had to show, by a preponderance of the evidence, that the defendant was the person pictured on that license?
Yeah, yes, that the defendant,
Was the person pictured on the license that had someone
That it was
else's name on it?
yes, it was a
Okay.
false or fraudulent counterfeit license.
Okay.
Yes.
Now, you've said you didn't admit the license, so the judge couldn't look at the picture.
That's correct.
The only testimony I see, and I may be missing something, is question from the attorney and the New Jersey, this is to the trooper, and the New Jersey ID that you found. The photo on that ID, was that Mr. Williams? And the answer is, and I quote, and your opposing counsel quoted this language also, quote, "I believe that it was Mr. Williams, yes." That's it. That's all you got, right? I believe that it was Mr. Williams.
Yes, we have that, and then we have the evidence that was presented.
Yes, I understand. The evidence is that clearly Mr. Williams isn't Eitan, whatever the guy's name is. That's fine. But it has to be his picture on the license, and all you have for that is, I believe that it was Mr. Williams, yes. Is that strong enough to support a finding
I would suggest that at
by a preponderance of the evidence? It is, I believe it was, could make it more likely than not. He doesn't even say, I concluded it was, which could have been the answer to this, yes, it was Mr. Williams' picture, and then we wouldn't be talking about this. I believe
that in addition to that statement, as well as the printout of Mr. Etal that came in during the closing, I believe that showing that he was a white man, and I believe that would be enough at a preponderance of the evidence standard. The judge can certainly, as the fact finder, can credit.
Well, they have
the
to, I don't know what that
statement.
means, can credit, they can, if he had said, it was, then he can decide, okay, I trust that guy's judgment. I believe that it was,
Well-
right? He can't just believe it, he has to conclude, doesn't he?
I mean, so this would be the first time he ever saw this defendant. He did say that he got a good look at him. I think that would be, I think it's enough. I mean, he doesn't know the defendant, so.
Well, which way is that? He doesn't know the defendant, he's seen him for 1 second at the window of the car.
Well, he did say he got a good look at him.
It's a good look at him.
And he
He
knew
looks at
that
the
the-
license, he says, oh, I believe that that's this guy.
I would
And
suggest.
you think that's enough for a preponderance,
I would
more
su-
likely than not, that his belief was in fact the fact, that it was in fact true? Okay. I don't know how we're supposed to sort that out. I believe isn't,
I would suggest that at a preponderance of the evidence standard at a probation surrender hearing, if you add to that the printout with Mr. Etal showing that he's a white man and the defendant was a black
I
man, I
understand
would
he's a
suggest
white
that's
man,
enough.
but the point
I mean,
has
the
nothing
judge-
to do with that. You can't, he doesn't get to go back to jail because he had an ID with some other African-American man's picture on it, right?
That's correct.
Okay, so the fact that the other guy was white gets you a tiny bit along the way. It's this, though, is the critical point. Not, I thought that wasn't the guy, but I think it was the defendant. Because then he's the one who's committing this crime.
And he's the only one in the car
Sure.
with the license on the passenger seat next to him, and the defendant's witness himself
He does
testified
not
that
present the fake license. He presents his own license, admittedly suspended, or we don't even know that, right? But he presents his own license.
That's
He doesn't
correct.
present it. He doesn't assert, this is me, I'm from New Jersey. He doesn't do what you might think someone would do with a fake ID. It's just sitting in the car and found later.
and he's the
And
only...
it's a rental car.
But he's the only person in the car, and the guy that rented him the car testified that they would have cleaned the seats off before renting it to this defendant.
Okay.
You also have the evidence of him having aliases and his altered social security numbers in the past.
That's correct, and that's ultimately, the trooper testified, that's ultimately why he charged him, because he saw those aliases and the dates of birth, so.
And you said that if we accept your concession, we have to remand, even though the second, the one we're just discussing, if that was sufficient? I mean, how many grounds does the Commonwealth need to violate someone's probation?
Well, I guess it would just be one.
So if the second one is sufficient, why do we have to remand? He was reprobated, wasn't he?
Yes.
No, he
No,
was
I'm sorry,
sentenced.
he received a,
The judge doesn't have discretion on a probation violation as to what sentence to give. He's already been sentenced.
he's already been sentenced, that's
So
correct.
if you're right on ground two, why would we have to remand?
I thought it was to find out whether, my understanding would be that it would be remanded to find out if the judge still would have found that he had violated his probation on the driving on a suspended license, even without the notice.
Let's assume we accept your concession on that one, and he's only going to be violated on the second one. The judge has to rehear that?
I mean, they could find him in violation for just the one, for just the forgery or the misuse of a
Right.
motor vehicle.
And then once he's found, then
Then he's
the
in
sentence is the
violation.
sentence.
If it's revoked, the judge would have to, on remand, conclude that even though only one and not two crimes was shown,
He would
that
still
he
have
thought the proper disposition was revocation rather than additional conditions, reprobation, whatever, right? I mean, it has to, we don't know what the judge who sat on this would conclude was the proper outcome, even though there is a finding of a violation, right?
Correct. He would have to, yes, he would have to decide that he still would have given
There
him
wouldn't be a new
that.
hearing on the facts, it would be a new remand so that
On
the
the-
judge can decide what the proper disposition is.
Yes. If there's no further questions, then I would rest on my brief for
Thank you
any
both.
unaddressed issues. Thank you.
Our next case is 22P471, Commonwealth versus Gomez. Mr. Matthew.
May it please the Court, my name is Attorney James Methy, and I represent Gerardo Gomez in this appeal. The first issue in my amended brief is that the judge should have allowed a required finding of not guilty on the carrying a firearm charge. I would just go over some of the facts briefly for the Court. Ms. Brooks, who was observing this incident, did testify that she saw something black in my client's hand, and it appeared to her that it was a firearm, and she made a motion in the courtroom about looking like it was a gun.
Pretty sure from the transcript she did this.
Right, the judge asked her, she made a motion like this apparently, and the judge said, do you think it was a gun?
Which I think could a fact finder reasonably conclude that this indicates that he was employing a gun, coupled with the fact that the other person was yelling, gun, gun, and then they later found a gun in the car.
Well, I understand your point, Your Honor.
Thank you.
What I would argue is that in this particular case, Ms. Brooks testified she didn't have her glasses on. She needs her glasses for reading and seeing, and she was vague about how far away from the scene she was. First, she was...
Those are jury arguments, right?
Well, I understand that that's what the Assistant DA argued in her brief. That goes to her credibility, her reliability. I would argue that at what point, though, does it become so unreliable that the judge shouldn't even accept it? I mean, how far away does somebody have to be, and how bad does their eyesight have to be before it's so unreliable that you can't even use it as sufficient evidence? That would be my
But aren't we looking at sufficiency, and so we're looking at the evidence in the light most favorable to the Commonwealth? And
Yes.
even if there were some questions about this person's eyesight, as Justice Meade just described, there are other sort of confirming circumstances. And I would add to his list that the gun was found where your client was seated.
That's correct, although I think Ms. Brooks testified she saw him in the driver's seat, but the police testified when they got there he was in the passenger seat. So.
Right, and the gun had come from the trunk of the car, and then when they found it, it was in the glove box in front of him in the passenger seat.
That's correct. Ms. Brooks testified she thought he saw him take it out of the trunk of the car.
Maybe we should move on to your second issue, because one of the questions that I have is, this very issue is pending before the Supreme Judicial Court, right?
That's correct. I'm aware that that case, Commonwealth versus GERARDO, was argued on December 5th. And I am aware also that this court rejected this argument in Commonwealth versus Griffith, which is an unpublished decision in November. But I felt like I needed to amend my brief to preserve
Are you asking us to hold our decision until the SJC rules?
I would prefer that, Your Honor, because obviously I know this court has to follow decisions of the Supreme Judicial Court, so I think it would make sense to defer your ruling until the Supreme... Pardon me, Your Honor?
They're sticklers about that.
I think it would make sense for you to defer your ruling on this issue until the SJC decides that
You would
case.
agree, though, if we were to adopt your argument, that is a wholesale change in our jurisprudence about the burden of proof when someone possesses a firearm, right?
Yes, I understand that since I think it's 1844, the case law says that the defendant has the burden to come forward with evidence that he has a license. And then,
It's not readily apparent to me in the SCOTUS decision that, and that dealt with the New York firearm scheme, that the lack of a license is now an element of the offense. So can you connect those dots for me?
well, that's true. The Supreme Court didn't exactly say that, or didn't say anything about burden of proof, or it has to be an element of the crime.
So how does
but they
that
did say-
case help you?
Well, they did say, though, that a person has the right to carry a firearm in public for self-defense, and I think the next step to that is if that's a constitutional right, then it should be an element of the crime the Commonwealth should have to prove, and not force the
But
defendant
how did you
to-
get there from the SCOTUS
Well-
decision? That's what I'm struggling with.
Well, I think I
You
just
could tell me
explained
it's
my
a new
position.
argument and it's a new creative argument, but the decision doesn't say that, right?
That's true.
Okay.
Can I ask you a question that maybe your colleague will know the answer to more than you? When someone possesses a firearm in their residence, which has long been recognized now as a Second Amendment right, although as with these public possession, licensure regimes are not per se unconstitutional. In the home, one has to have, in Massachusetts, a firearm ID card. When someone is prosecuted for possessing a firearm in their home without a firearm ID card, do you know if the Commonwealth utilizes this Section 7 presumption and requires the person whose residence we're talking about who had the firearm to produce proof that they have the FID card? Or do we in fact say it's an element of the offense and the Commonwealth bears the burden on that? I haven't seen any cases, I wasn't able to find a case on that, but these cases, I mean, it's been 11 years or something since McNally. There must be prosecutions for this. Do you know what happens?
I don't know the answer to that question, Your Honor. I don't do trial work anymore, so
Okay.
I don't know.
And are we reviewing this for substantial risk?
No, I would argue, as I did in my brief, that it's preserved because it would be futile for counsel to argue as to anything else because the law in the Commonwealth has been, as we stated.
So you're saying it would be harmless beyond a reasonable doubt would be our review?
That's what I would argue, yes.
Was there a motion in limine? Was there anything that the defendant brought pre-trial on the question of this licensing?
No, there wasn't. I would just say one other thing, that a key point in this case, as opposed to some other cases, that there was no evidence at all in this case that my client didn't have a license. In some other cases, you see some facts that the defendant didn't have one or couldn't have had one, but in this case, there was no evidence that he didn't have a license. So I would argue that if the SJC or this court were to find that it should be an element of defense, then basically the Commonwealth didn't carry their burden in this particular case. I think that's all I have. If there's no further questions, I'd ask
Seeing
you to.
none, thank you.
Thank you.
Ms. Jordan.
Good morning. May it please the court, Darcy Jordan on behalf of the Commonwealth. If I could start with the first issue, I think it's pretty clear it's in light most favor of the Commonwealth. The judge correctly ruled denying the directed verdict. I think the more interesting topic is issue number 2.
And you say we're reviewing for substantial risk.
Yes, and I think part of that, obviously it's a constitutional question, and I think part of it, in my understanding of constitutional law, where it's raised by a defendant who didn't take advantage of that law, that would be the standard. So it's not a case where this defendant tried to get a license and was somehow denied. I think that would be in a different posture, but
Even if we were to review under harmless beyond a reasonable doubt standard, would the result be the same in your view?
yes. Absolutely. I think, Justice Blake, you started to kind of allude to this or stated it point blankly, that Bruin doesn't change any law in Massachusetts. Frankly, it doesn't really change any law, however.
What about Gauss's dictum that suggests that if there is a constitutional right involved, that the Section 7 burden-shifting regime with respect to licensure can't be employed? I agree with you about the Winship argument. I don't understand how the court reached that Winship conclusion, frankly, in Gauss, but we're bound by that. But they also indicate, and they cite a case called Harrington from the District of Columbia Appeals Court, not the Circuit Court, but the local appeals court in the District of Columbia, that says you can't have a burden-shifting presumption like that if it's a constitutional right. You have to have the culpable conduct, in this case, absence of a license. The culpable conduct has to be an element of the offense with the burden beyond a reasonable doubt on the Commonwealth. And it does seem to me that Bruin says that having possession of a firearm in public is a constitutional right, such that the licensure requirements have to be a certain way. That is a change in the law, at least I don't think it's a surprising change. Again, I didn't really understand the emphasis on residents versus non-residents in Gauss itself, but there it is. So I'm not sure I understand why that doesn't mean that there's a constitutional right here, and if that's the rule that you can't use Section 7, where the presumptively illegal conduct would be constitutionally protected, why that doesn't require reversal here if we don't hold the case for the SJC case.
Okay, I understand your question. It's a meaty one, so I'm going to take it piece by piece. First, if we could just talk about Bruin and how, if at all, that changes the burden of...
Not the burden of proof, that articulates the scope of the Second Amendment right more broadly.
I understand, and I think what you're saying is, well, now with Bruin, aren't we saying that everyone has a right to carry?
In public.
And now that we have to prove licensure. And I'm going to ask the court to look at Heller, because I do think Bruin is a comparative to Heller. And because what Heller says, and I think Bruin heavily relies on and adopts, is that the Second Amendment is a limited right. And that limited right is to law-abiding, reasonable citizens. And that universe of who is a law-abiding, reasonable citizen is defined and cabined by the constitutional regulatory system. So in a way, Bruin doesn't really change anything, because Bruin...
That's fine, but Gauss says, maybe wrongly, and maybe in dictum. Gauss says that the right that's recognized is possession in the home, and it strongly implies that if the crime here were possession in your home without a license, that it would be the Commonwealth's burden to prove without a license.
Yes.
And now we have an explicit articulation. That seems like me. Apparently I angered my phone with my tenor.
I understand. Your point is, in Gauss, part of Gauss's ruling, it seemed, turned on the fact that Gauss himself didn't implicate the right to carry outside the home. So in a way, Gauss is narrowing it to this only applies to the home. And in the footnote is saying, well, we don't know what happens if it was outside the home. And I think what I'm saying and arguing, well, now we've arrived. We've arrived, and Bruin is saying, now you have a right outside the home. And my reading of not only Gauss, Heller, Bruin, and frankly all Second Amendment precedent is saying that that right is not unfettered. And that's heavily relied upon Heller, which says the Second Amendment is not whenever, however, whenever you want. It is subject to regulation
But
by law.
you agree that if Harrington, this D.C. Court of
right.
Appeals, is the law, that now that Harrington rule would apply outside the home as well as inside the home. Now, I'm not saying that is the law in Massachusetts, but I'm saying we're the intermediate appellate court, and we have Gauss to look at. And I understand the Winship argument. I think that might be wrong. I've never understood this. It's a crime, and then you can get to disprove. I mean, can we make everything a crime, and the affirmative defense is, no, I paid for the item? I mean, it's, right?
Sure.
Right,
If I can take Harrington first, and then maybe we could talk about affirmative defense in Massachusetts. Is that,
affirmative defense I'm fine on. It's really this Harrington.
Okay, so Harrington, I think, is really an outlier. I think that Harrington would not be found the way it was found if it had been in Massachusetts. First of all, Harrington had to do with possession of ammunition, not a handgun. Second of all, Harrington, the defendant himself, possessed the ammunition prior to the opinion in Heller. So he kind of falls in this no man's land where at the time, the statute that applied to him was later struck down by Heller. And that said, basically, no one can get a firearm license. So in Harrington, the case, they said, hey, this guy couldn't even get a firearm license to implicate the corollary right of having ammunition. Now, there's more. There's more for Harrington. The other differential in Harrington is that the Washington, D.C. statute, unlike in Massachusetts, the statute itself has a burden of persuasion, not a burden of production. And in Massachusetts, it's clearly precedent in Gauss, which relies on Jones, and Powell, that is okay. So I think those we cannot analyze that statute similarly.
All you're telling me is that the premises of Gauss were wrong. And that's a fine argument, but we're bound by Gauss.
We are bound by Gauss. But again, I don't think that one sentence and footnote in Gauss changes.
The whole paragraph addressing the first argument, which is you can't make exercise of a constitutional right, which it describes, as I understand it, was subject to licensure. But that's not how the SJC did it. They didn't say the right is an absolute, and therefore you can make it the presumptive unlawful conduct. They said if this were in the home, it would be different.
Is Mr. Gomez in his home?
Mr. Gomez is outside.
That's right. And Bruin now tells us quite clearly, outside you have the same right to possess a gun with reasonable licensing requirements as inside.
I agree with you, but I think what I see as the difference as being that the Second Amendment right is not unlimited. And I think the defendant's argument here, and I think what Your Honor is also saying, is that outside the house, it's somehow unlimited.
No,
and inside
you didn't hear me say that for 1 second. I clearly said, subject to licensure, outside as inside, reasonable licensing requirements. Let me ask you this. In the Commonwealth, this is what I asked your brother. If someone is charged with possession of a firearm in their home without an FID card, who has to prove the absence of an FID card?
I think it's the same.
You think Section 7 applies?
Yes, Section 7 doesn't apply only to firearms. It's a criminal.
I understand that, but after Gauss, I don't see how. Now, maybe it's possible. Do you have any case in which an FID absence of an FID card for an in-home possession of a firearm where the burden was placed on the defendant, not on the Commonwealth?
I do not. I have not.
Do you have any case from any jurisdiction in the United States where licensure had to be proven post-Heller inside the home, where licensure had to be proven by the defendant, not by the prosecuting authority?
All I can answer to that is that other states have different schemes and different laws.
I agree. So your answer is no.
I can say, I don't personally, I did not, because I solely looked at Massachusetts law, which does not require that. It's definitely precedent that there's only two requirements for
Do
possession
you
of
agree we should
firearm.
hold the case for GERARDO or whatever that?
Well, I think that's an interesting question, because if I remember correctly, that argument happened, I don't think it was briefed as fully on the issues. So I think the record isn't as solidified, maybe, that had both parties briefed after Bruin. So I think it might.
Well, it was argued December 4th.
It was argued, but I believe if I had to look back, I think the briefing was not.
I mean, I'll have
maybe
to look,
it
but
might have
there's
been briefed.
amicus briefs from a number of organizations on this point.
I could be wrong, but I watched the argument as well. Obviously, I'm invested, but it's my understanding, and I also corresponded with the prosecutor in that case. So I don't think it even kind of got to the level of this briefing, which I know is a supplement and amended, but that's my understanding. But
So you think we shouldn't wait just to even see if they offer us guidance?
I think it would be wise to wait and see what the SJC says. Absolutely. I see, at least for judicial economy, to see what they rule. But I understand why this case here is still ripe for the court as well.
No, that's clear. We could reach it. That's clear.
Seeing no other questions, Commonwealth returns brief. Thank you.
Thank you. Thank you both. The next case is 21P 1154, GRANDOIT versus MCAD and another. Mr. GRANDOIT, you get to go first. I think if you've seen at least the last argument, you can come to the podium. Each side gets 15 minutes. You don't have to use all of your time. We've read everything. Only the panel will address questions to you, not your opponents. They will not interrupt you, and when it's their turn, we ask that you not interrupt them as well. So with that, you may proceed.
Good morning, Your Honors. My name is Gerard D. GRANDOIT. In fact, I'm pro se Gerard D. GRANDOIT on behalf of Mr. GRANDOIT. The reason that before I start, I like to ask, could I use, like you said, I don't need to use all of the time. Could I use 5 minutes and wait for them to talk, and then after that I could use the other 10 minutes?
I apologize. I should have explained that as well. There's no rebuttal, so you have to make your entire argument now,
okay.
and then they get to make their entire argument, and then we'll take the matter under consideration.
Okay, this is how the event start. I had a life insurance policy, and then the life is canceled. They do to the company of American Health say that they cancel the insurance. Wrongly, they said that it was a credit card who caused them to cancel the insurance. And then after that, I think they were discriminating with me at the time. And then after that, I had a stroke, and we have agreement to reinstate the insurance. They did not do it, and then after that, I had a stroke, and I was not able to do anything. And then after the stroke, and I contact them, and they asked me, the insurance tell me they're gonna. They could settle with me to reinstate it instead of paying damage to me and and then they ask me I have to come out with money and everything to reinstate it. I feel that the way they were talking to me and they know who I am, I tell them, explain to them who I am, and then they did not reinstate the insurance, and then I feel like they were discriminating against me. And I filed a case at the Massachusetts MCAD. And then after I finished to file the case at MCAD, they have a process. I'm not here for the substance of my case. I think the substance of my case is supposed to come at the second time. And right now, I am here for process and procedure. MCAD has a process. The process is they have a guideline. They have a my like complaint of discrimination, or I say charge to make it easy for me. They're supposed to take my charge of discrimination and launch it to the insurance. After the process said after the insurance supposed to receive my complaint from MCAD, they have to mail me a copy of position statement. This is what the regulation of the law from MCAD said. This is the regulation. I'm just going by the regulation. They have to mail me a copy of the position statement, and then MCAD. They did not mail me the position statement. This is between MCAD and the insurance. I think they failed to do this thing. They might let MCAD know, or they might not let MCAD know. I don't know. MCAD.
Mr. Grandoit, you're not a lawyer, I take it, right? Are you trained as a lawyer, or you were not?
I am not a lawyer.
Okay.
I am not a lawyer.
Okay, so I understand that, and I think that makes this very difficult for any non-lawyer to participate in a legal proceeding. However, and I also recognize, of course, there are serious problems of discrimination in society,
Yeah.
and maybe at insurance companies, and maybe in lots of different places. I was on a panel of this court that heard one of your cases before.
Yes.
I don't know if you're probably aware of that.
Yes, Your Honor.
And we tried, I thought, very hard in that case to issue an opinion that even a non-lawyer would be able to understand what we were saying. Although I don't know that we've succeeded, because you have brought a number of claims to the MCAD. They have repeatedly failed, sometimes on procedural grounds, like this, you say, and sometimes on substantive grounds, like the last case we had. They have failed to go forward with your complaints, to make the finding of probable cause and to continue their own proceedings. And I think what we were trying to make clear in the last decision, which I do think we tried to write it in a way that would be understandable even to a non-lawyer, was that those kinds of questions, did they do something wrong? Did they, on the substance or the procedure or anything, that those are not reviewable by a court like us? That what happens instead, if you are dissatisfied, is you may yourself bring a lawsuit against the insurance company, right? There are two avenues. You can go through MCAD, or if they don't go forward, you can bring your own lawsuit within certain times and so on. And I understand why that may be frustrating to you as a citizen, because you would like MCAD to operate the way you say they're supposed to, and maybe they are supposed to, and to both procedurally and substantively. But I think what we said in the last case, and it's not some new rule, we're just telling you what the rules are, we'd have to follow all the rules, that the rules are MCAD can get it wrong, can do it wrong, And what you can do about it is not bring a lawsuit against MCAD. And do you have, I don't know if you understood that that was the gist of what we said the last time. And that's not because discrimination is okay, and it's not because we want MCAD to not follow the rules, and it's not because we want MCAD to fail to find probable cause when there is, but that's the system the legislature set up. And we can't do anything about that. And so, but you could, if you believe you were discriminated against and they have failed, you can bring a suit yourself without them against the alleged discriminator. In this case, that would be the insurance company. Is what I'm saying making any sense to you, or does that ring a bell, or no?
Yes, Your Honor, I did not get a chance to finish explaining. The time is running.
No, I'm sorry. Please, you have more time.
Time is running.
No, go ahead.
I think I only speak 5 minutes, and then after that, you talk.
Go ahead.
If I could have the other 10 minutes, it will be great, because I didn't get a chance to explain
You have what
everything.
time you have, including our questions.
Yes, Your Honor, what you said is right, but there's the two different things. They doing the right way. They do it. It's not like they're doing a wrong-day motion to dismiss or motion to fail to. They do it. This is exactly what you're saying right now, Your Honor. They do it in terms of a complaint. I did not file a complaint. I filed a complaint for judicial review. There's a big difference between a complaint of judicial review and a complaint and a regular complaint. A regular complaint, they could file this, what they do to the court. But judicial review is different. It's whether MCAD is the superior court as jurisdiction. They file two things. It's a lack of jurisdiction and failure to set a claim. First, about the jurisdiction. They said about this, they are not specific. It's not, I'm sorry, Your Honor, it's not only on Superior Court. This thing has been going on from a lot of courts around the United States. People file a motion for jurisdiction, but they have to be specific on the jurisdiction, because the Superior Court has appellate jurisdiction, Superior Court has concurrent jurisdiction, Superior Court has a conclusive jurisdiction, subject matter jurisdiction, and so forth. But they have to be specific. A territorial jurisdiction, like right now. They might say, this court doesn't have jurisdiction on me. You have territorial jurisdiction on me. You have the right to decide or whatever you want to do with me or whatever you want to do with this case. Once the court make a decision, it has jurisdiction. But what kind of jurisdiction it doesn't have? That's the one thing. Once the court found that they said that I don't have, Superior Court doesn't have jurisdiction. Once Superior Court finished to have the jurisdiction, Your Honor, that's the time I will prove whatever jurisdiction that the court has for my claim. Secondly, they said I don't set a claim. They said I don't set a claim. The claim was in the complaint. They did not argue about my complaint on the things. They said that I don't set it. That's the two things: jurisdiction and failure to set a claim. Once I say the two things, that's the time I will prove my claim from the complaint that I file.
Well, I think this is why, one of the reasons why it's very difficult for non-lawyers to participate in the legal system. Because failure to state a claim, if you went to law school, which takes a long time and is a lot of training, of course, you would see that it's not that you didn't merely state a claim, but that it was a claim that the law does not allow us to provide relief upon. It is not that you didn't set out a claim, of course you did. It's that that claim is not one the court may provide relief upon. There are some things courts can provide relief for, and some things not. And I feel like you are consistently asking the MCAD to do something. They are consistently failing to do it, but courts can't address every issue with the MCAD, and that's why the legislature has given you, the person who is discriminated against, the right to bring your own suit against the insurance company. That's your remedy if they do something wrong, not judicial review, not any kind of complaint. Now, there may be something different about this, and we'll hear from your brothers, and we have your briefs, and obviously we'll look at your case with some care. You should know we look at your cases with great care. I know I do, and I know my colleagues do as well, and it's not some willful blindness or inability to understand what you're saying. I just think that it's a question of what the law is.
Your Honor, I did not ask for relief. I am only filed the complaint for judicial review on the process and procedure. What is the process said? The process said what they do, they argue about case, the process allow me, every court, every lower court, there is a review at the higher court. They are talking about I'm only for the process to return the case back to MCAD of what they're supposed to be doing. I was aggravated. I did not receive a position statement. I did not file a rebuttal. I did not receive a notice to appeal to the court after the final decision. This is the thing that caused me to appeal to Superior Court, for Superior Court to return it back to them and follow the procedure. That's the only thing that I'm asking.
That is a kind of relief, and it is a kind of relief a court may not be able to grant you, not because of anything you're incorrect about, but because courts can't grant every kind of relief that you may need. But you may bring a suit yourself.
I did that in federal district court about this is something different. I filed a complaint. I didn't want to talk about it because I did not talk about it. Like you said right now, Your Honor, you mentioned it. This thing is something different. It's already on federal district court. It's pending on federal district court. Right now, I file a complaint for I am on discrimination. When you file a case in MCAD, once MCAD, if something has been going wrongly, I'm sorry, Your Honor, the process goes so long. You got to finish all the administrative procedure first. Your superior procedure first, appeals court procedure first, judicial court procedure first, Supreme Judicial Court procedure first, and then you file it in Washington, D.C. Once you finish to file it in Washington, D.C., that's the time. It's a long process to file a case against MCAD once a person denied. But the lawyer said that I could file on Chapter 159, 150B, Section 9, but they're talking about that if MCAD was found probable cause, that's the time I could file it. If I did not agree with MCAD, I could file a new complaint. But once you get a lack of probable cause, I have to, no matter what. I'm sorry, Your Honor. That's with the process.
Okay,
The process and the law.
Mr. Grandoit, we've read your brief, we understand your argument, and your time is up, so we're going to...
okay, thank you, Your Honor.
Thank you very much.
Okay, sure, thank you.
Good morning, Your Honor. My name is Peter Mimo. I'm counsel for the Massachusetts Commission Against Discrimination. And members of the panel, the Commission asked that the panel dismiss this appeal because Mr. Grandoit, as has been observed earlier today, has no right of appeal from the dismissal of a complaint before the MCAD for lack of probable cause. On several previous occasions, this court has affirmed this basic principle regarding previous appeals by this appellant, Mr. Grandoit, and respectfully, nothing about Mr. Grandoit's present appeal or his presentation today should alter that. Your Honors, this matter concerns, again, an appeal by Mr. Grandoit from a dismissal by the Superior Court. A Superior Court judge dismissed Mr. Grandoit's action in which he improperly sought judicial review of an MCAD investigating commissioner's decision to dismiss his discrimination complaint, which, as this court has repeatedly determined, he may not do so. If it pleases the court, I can briefly review the Commission's handling of this particular complaint and the investigating Commissioner's
We've read
decision
your
to
brief
dismiss
as
it.
well.
I understand, Your Honor. And so to address particularly, Your Honor, what we heard just recently from Mr. Grandoit regarding the notion of the notion that he has to condition a Section 9 complaint, a private right of action, upon a finding by probable cause by the Commission. The answer, of course, is that's not the case. A Section 9 complaint is de novo. Mr. Grandoit would be free to bring a complaint under Section 9 and would not be bound by what the Commission had done with his complaint previously. He can do so within 90 days after filing a complaint with the Commission. This is all well established. What the Commission had when we received this complaint, Your Honor, we have under our regulations the authority to decide whether to review and to authorize an investigation. And we determined after review of his complaint in this matter that we were not going to do so because Mr. Grandoit's complaint in this matter was both untimely and failed to state a claim. And those are precisely the types of grounds we can decide not to review or not to authorize an investigation under our own regulations, and we have done so. And by the way, that precisely explains why Mr. Grandoit did not receive a position statement, because we did not authorize an investigation in the first instance. The basic process, Your Honor, is that when the investigating commissioner determines to investigate a complaint, we do so, and at that point we will then serve a complaint upon the respondent. And then after investigation, we may decide to issue a probable cause finding. If we do so, then we have the matter be conciliated. And if it fails to be conciliated, then we certify the matter for public hearing for a hearing commissioner. Your Honor, I can continue to go on, but the fact of the matter is that there are multiple steps that have to get to before you get to a final agency decision that's subject to a judicial review, and Mr. Grandoit hasn't gone past the first step in this particular matter. Your Honors, we've been down this road before. We have a published decision by this court that made it very clear about the very arguments that we've relied upon again in seeking dismissal of this appeal, and we would ask that you do so again. Your Honor, we would like you to take note of the Superior Court's action in this in a related matter. The Commission, as you had indicated before, is committed. Its mission is to eradicate discrimination in this Commonwealth. We have dedicated professionals. We have attorneys, investigators, mediators who are all working quite hard and devoted towards this crucial mission. And when Mr. Grandoit continues to bring a series of baseless lawsuits against the MCAD, and I'm paraphrasing, a sanction that the Superior Court has entered against Mr. Grandoit, it in fact does create a needless drain on our limited resources. And I would like the court to take note of that when disposing of this appeal, and we ask that you do so. With that, Your Honors, if you have questions for me, I'm happy to answer them, of course, and otherwise we rely on the arguments we raised in our brief.
Seeing none, thank you. Mr. Rosenberg.
Thank you.
Good morning, Your Honors. May it please the Court. My name is Aaron Rosenberg on behalf of the appellee American Health and Life Insurance Company. I won't rehash what's in my brief or what MCAD's counsel just said.
Is there a suit against you by Mr. Grandoit?
Other than the Superior Court appeal?
The reference to what's happening in federal court?
No, I don't believe that was a reference to my client. I don't know what that's a reference to. As far as I know, there is no other claim. The only claim was the claim that was dismissed in this case. As MCAD's counsel stated, that dismissal was appropriate and in compliance with 3 cases brought by Mr. Grandoit that were decided by this court. As Mr. Grandoit himself said, this appeal is about the process. That's the precise issue that the Superior Court did not have jurisdiction to review on the complaint that Mr. Grandoit filed. Unless you have other questions for me, I'm satisfied resting on my brief.
Thank you.
Thank you, Your Honor.
Thank all of you. Thank you, Mr. Grandoit. We'll take a short recess.
session. Please be seated.
Our next case is 21P 1093 HT number 1712 versus the Sex Offender Registry Board. Mr. Tomasco.
Thank you, Your Honor. May it please the Court, Alexi Tomasco for Mr. Doe. I'm appearing in a limited capacity for argument in this matter. I wanted to start with the second and third argument in the case, and I think substantively they dovetail for similar reasons, whether we're viewing this as a constitutional argument or a substantial evidence argument. I first just wanted to address, and this is the Hansen study and its impact on high-risk offenders after time. I want to just briefly address the board's waiver argument. In footnote 3, the board suggests that the Hansen studies, any reference thereto should be waived. I'd note, first of all, that footnotes don't rise to the level of appellate argument, and so the waiver argument itself is in fact...
Was it presented below?
...waived. This study was not, Your Honor. It's not in the record. I also understand that there are some adverse rulings and unpublished decisions regarding this court's ability to look at studies that were not in the record. I think the SJC put this question to rest in 6729. This was just in November. And there the court established what I refer to as the Chennai-Green-Hansen rule, which says that an appellate court may consider Dr. Hansen's work in the first instance on appeal in appellate cases litigated by attorneys Green and Chennai. I suspect the rule might be slightly wider than that, but in that case, Attorney Chennai offered Dr. Hansen's unpublished testimony for the first time in oral argument, not in the board, not in Superior Court, not before this court in writing, not before the SJC in writing, and that was a substantive and considerable portion of the court's ruling in that case. So then turning to the substance of these arguments, the board's next argument is essentially Hansen who. Hansen doesn't really matter in this case. He's irrelevant, and we can just go by the factors. And I think this misapprehends the burden that the board has. And it's very clear in 205-614 that the board bears the burden of justifying the appropriateness of its classifications. That's not just an empty rule. That classification must be grounded in the available literature to ensure that an offender's ultimate classification is the product of reasoned application of validated empirical studies. There is no study in existence, let alone one the board can point to, that shows any kind of even moderate risk of reoffense after 20 years. In the case,
So as a matter of law, it's an error to classify a sex offender as anything other than level 1 or not at all if they haven't offended in 20 years?
The board has the burden for providing a study, an empirical study.
No, you can explain, but can you just answer my question first?
If the board has a study that supports its classification, it could do that.
I said, my question was, as a matter of law, you're telling us that the board cannot classify someone as a level 2 if they haven't offended in 20 years.
I'm suggesting that the requirement in that case is not just a factorial analysis.
Let's go with yes or no.
Sure. Currently, no.
Thank you. Now you can explain.
Okay. One of the burdens on the board is not just to do its factorial analysis, it's to make sure that that factorial analysis is supported by empirical studies. If there were an empirical study, that answer would be different. In the absence of an empirical study, any type of factorial analysis is not supported where the actual studies stand for the opposite proposition. So I apologize.
Your position is that 4.2% recidivism rate, is that what we're saying after 20 years? After 10 years, it's 4.2%?
So in that study, in the header, there's the 4.2 discussion. In the actual text, Hansen explains that the risk decreases about 50% every 5-year period.
How many percent?
50% reduction in...
That's in the, I didn't see that. I saw that it reduced some. I didn't see that number, 50% every 5 years. Is that in the article?
I reread it this morning. I'm sure I could have gotten it wrong, but that was 50%. And in fact, in that study,
So you're now saying that therefore 4.2 becomes 2.1 becomes 1.5.
and then we start reaching just normal
1.05.
rate, not something that's isolated to sex offenders. But I would note
And
that,
presumably, although I know nothing about it, if, for example, the person was committing a huge number of non-sexual crimes, might we, since there are other factors that the legislature has said to consider, might we reach a conclusion that despite that number in that study, these other factors played some role in risk of reoffense that weren't fully captured by that mere statistic?
there's a couple of questions that, that I'll go about. First of all, I'm going to answer the larger legal question. In this particular study, it makes clear that the question is whether or not there's a new sexual offense, not whether there's a new offense. So
I understand that. We're on the same page about that.
So I think more generally the question is, what if there are 37 factors that go against a petitioner, and then one factor, 20 years offense-free time, in favor of the petitioner? And this is the same answer I give to Justice Meade, is that if there's an empirical study that says under those circumstances, there's a moderate, high risk, any kind of even substantial risk, then the answer is yes, that's fine. But this is the other burden that the board has, that we jump right to this factorial analysis. The board has to support this with empirical studies. It's not sufficient.
Oh, yes and no. There may be you've got an empirical study about this, but a person may have a variety of factors about which nothing has been written or nothing adequate.
Oh, absolutely.
Right?
The SJC has addressed that as well. This comes up in the youth case, in the gender case. There's questions as to particular minorities where if the studies do not adequately address the likelihood of recidivism in a particular group, not even a protected class, but especially a protected class, the SJC has said there's serious problems with the validity of the studies here. And in those cases, in particular gender, the court sent it back and said the studies that the board was relying on in that case weren't sufficient because they didn't address the petitioner or the class.
And then how is the hearing examiner supposed to figure out what to do? Well, look at the study. The study says blah, blah, blah for men. It says nothing about women. Maybe women are exactly the same. Maybe they're totally different. He's got nothing. What does he do now?
Well,
the legislature has said these are the factors.
Right. The due process guarantees that are enunciated in terms of the requirement for studies trumps the statute. I mean, the constitutional protections are greater than the statute. The legislature, a regulation of agency can't obviate the Constitution. It's not permitted. The board always has the opportunity to hire an expert. If they had an expert that came in and said, I've done these studies and...
What if there are no studies?
That's, I think, the board's issue. It's the board's burden.
Apart from the legislative mandate of what the board is to do, including the CMRs, you're telling us they also need empirical studies to support classification decisions. And absent one, what happens then?
Well, that was a quote from 205-614. Mine is not to reason why.
That's 205, what's the number?
This is 466 Mass 594. And again, the quote, I have the two sentences.
Is that from the SJC?
That's the SJC from 2013. The board bears the burden of justifying the appropriateness of its classification, and the classification is grounded in the available literature to ensure that an offender's ultimate classification is the product of reasoned application of validated empirical studies. And again, this is the distinction between our punitive or conduct that would violate the due process guarantees and what happens here. In order for the board to exist, there has to be this basis. They can't just wing it, and that's just
okay. So every study ever done at some point was done on men, and now the SORB has its very first woman sex offender, and it's got all this great data But all the studies are about men. You're saying that a woman, even if she's, let's say that she fits into some of these, repetitive and compulsive, extra-familial victim, whatever, but there is no study that looks at how these things affect women offenders. You think that as a consequence, it cannot be said by clear and convincing evidence that she is anything other than lowest level?
That case happened. The SJC decided that case. In that case, the hearing examiner excluded the expert testimony and the studies provided by the petitioner that said that the factors and the studies cited in support of those factors did not adequately consider gender. The SJC said it was completely incorrect to
Did they say that the person had to be categorized as level 1?
They remanded it for consideration of the studies that contemplated gender.
So there were studies in place.
Yes, and the board's regulations didn't cite them. The board didn't meet its obligation of providing empirical studies. And again, that's the 205-614.
Let me ask you this. In 2008, this petitioner, I believe that's the latest violation of a restraining order, is that right? Or the latest issuance of a restraining order, do we know?
I would need to double check. The restraining orders are all in the record, Your Honor.
Okay, so my sense was that there was something in 2008 that was about women but wasn't a sex crime.
Mm-hmm.
And then in 2015, we have a charged criminal action. I'm not saying that the hearing examiner pushed on these at all. I don't think the hearing examiner did. And of course, I'll ask opposing counsel how we're supposed to figure this out, given how much credit the hearing examiner actually gave your client. But how do we factor those into your 1.05%?
So this is the 2015 breaking and entering clause.
Yeah, but let's also take a 2008, I don't know if there is one, but imagine someone who has 14 years ago, they have a restraining order violation involving a woman, but it's not a sex crime, but it's this thing that we say shows, whatever the phrase is, disrespect for women or whatever.
Again, Hansen defines what the recidivism is in terms of subsequent behavior. It's not criminal behavior. It's reoffense sexually.
Yes,
and
but
I'll make
the
two notes
other
about
factors have to be considered by the hearing examiner.
They have to be considered, and then the final classification has to be supported.
Do you think you could get to a 2 with that, or you can't? It has to be a 1. Because of this study about this one factor, the fact that there are bits and pieces of other things in the other factors are not enough for clear and convincing evidence. I mean in real life. I don't mean in theory there could be a study. We have a real case here.
We have a real case here.
And I'm trying to figure out, are you saying that as a matter of law, because of the study about 1.05%, if I give you that, and I don't know if that's right, but the 1.05% with that, regardless of the other things, once the hearing examiner says, I am giving full mitigating weight to 20 years offense-free in the community, we cannot, he or she may not classify this person as a moderate risk of reoffense.
Where the regulations do not provide for any information on that, and where there is no study in support of that position, then yes, that is my reading of 205-614. I mean, it's simply that you need these empirical studies. I would just note, and again, I'm running short of time, in terms of the 2015 and 2008, even if those were considered and they're not under the study, the 8 years is still a triggering event where we're within the 5 and then 10-year period that is contemplated, which is still a drastic reduction.
Okay, but 4%, I don't know if 4% is a moderate risk or low risk. Do you?
The board has never enunciated that.
I'm aware of that. I mention it to Mr. Shanai almost every time I see him, that it would be useful to have some numbers attached to these things.
Oh, it very much would be, Your Honor, and we would be happy for that, and we would be happy for published opinions from the board, but we don't have either, so I don't think there's any sort of enunciated rule. There's nothing in the case law. I think the case law, in fact, is contrary to that says that is not how the analysis needs to be in terms of a direct static 99R or a direct percent chance of recidivism. It would be helpful, I think, Your Honor, both to me and the court. In light of the time, I'm not going to address the other question presented here unless there's any questions from the court as to that issue.
No, thank you.
I otherwise rest on the brief. Thank you very much, Your Honors.
Mr. Chennai.
If it pleases the court, David Chennai for the board. I want to first state on Doe 6729 or 6279, whichever it was, in the Supreme Court, Justice Kafka specifically requested that I provide a copy of Dr. Hansen's testimony from 2014 to the board regarding his testimony as to Factor 2, which I provided post-argument. So I didn't raise the issue or bring it forward sua sponte. It was specifically requested of me. Doe 205614, which is one of the many cases that I've lost in the Supreme Court, that case specifically said that at the time the board's regulation said these regulations apply to females as well as males. And studies had started coming out about the differences in female sex offending behaviors, and much different than male. And what the court ruled in that was that if the petitioner brings studies in of a characteristic that is not considered by the board's regulations, the hearing examiner has to consider those studies under Factor 37 in making a decision. And that was later brought up again in Doe 151564, where Justice Kafka, when he was with the appeals court, said that because the board's regulations at the time didn't deal with the issue of age, studies were submitted that said that aging offenders have a reduction in sexual offending or reoffending. At that point, Justice Kafka said the board had to consider those studies in determining an older offender's classification. Since that time, the board redid its regulations in 2016. It added for gender and added specific factors that specifically deal with female sex offending behaviors, dealt with age. It also updated the Factor 29, which, again, the Hansen study was considered, this 2013 Hansen study was considered by the board when it created Factor 29. It accepted the premise that the longer you are not committing sex offenses, the lower your risk begets.
So if the board accepts that article and accepts that after 10 years offense-free in the community, your risk of reoffense is 4.2%, all things equal. And if it further accepts that there is a further reduction after that from the 4.2%, today your brother says, and I haven't looked at the article, so I don't know, I didn't see this in the brief, but let's say by hypothesis he's right, that after 5 years that's cut in half to 2.1%, and 5 more years it's cut in half to 1.02%. And now we have an offender who is 22 years offense-free in the community. Now, look, I don't know how good the fact-finding process is. I don't know the real story of this. I find the nature of the crimes, it surprises me that it seems that this particular kind of behavior seems to have just stopped. But maybe that happens. I have no idea. That's what the hearing examiner accepted this and said, I give full weight to the offense-free time in society. Now, I thought I would flip through this and see the hearing examiner say, but in 2015 he committed a crime, larceny, and I believe that this shows an inability to conform himself to society, and therefore, despite that, I'm going to say this is clear and convincing evidence. And I never know what to do with these non-numeric, as you know, we've talked about this before. No one will tell me if 1% is low or high, 4% medium or high or low, right? But okay, so if we got 1.05, but he doesn't say that. He says that was quaffed. I'm going to give that minimal aggravating weight. How can we say that someone who on sex offense-free in society is at 1.05% and other conduct is minimal, how can we say by clear and convincing evidence that the risk remains moderate? That's my whole question to you. I just don't understand how we're supposed to assess that.
My understanding of the decision was the hearing examiner gave the individual's criminal record moderate weight.
I agree, but the criminal record ends, except for this 2015 one, it ends in like 1999. It's very, very old.
Right, but in the discussion, the hearing examiner in the discussion section, when he's discussing the risk and danger, starts with the premise and specifically says that it can't be overlooked that this individual was charged with crimes in 2015 and did have restraining orders as of late as 2008.
It gives them minimal aggravating weight, but has to get to clear and convincing evidence of moderate. Now, I have to tell you, and we've talked about this before, if you all won't tell me what percentage of recidivism rate is moderate, I don't know how to assess what's moderate or high or low, and you won't tell us. And you say we rely on expertise, but I haven't met these people. I don't, their expertise, I don't know what their backgrounds are. Maybe they're huge experts, and they certainly do this a lot. But I look at a case like this, 30 years? Would we go down to low at 30? How about 40? If the guy isn't 60 yet, right? He commits the crime at 19, it's 40 years later, he's still 59, so he doesn't get the sexual drop-off that supposedly comes at 60. Low? Moderate. I just don't know how we're supposed to say that. And if I can't even tell which it is, how can it have been shown by clear and convincing evidence?
Well, again, the board's looking at this as a qualitative analysis. You look at the statements, for instance, the hearing examiner has to look at the sex offending behavior.
It's terrible sex offending behavior, and it's repeated.
And that factors in. Also,
well, no, that factors into dangerousness, right?
If
he were to reoffend, it would be terrible, right? That's clear.
Well, no,
it might be the risk of dangerousness might be the highest, not the highest of all. We've seen terrible, but terrible, fully in the high category. But if he's not going to reoffend, he has to have both before you can.
Well, I think you're misstating the factors that apply to the sex offending behavior. Many of them go to risk. Factor 3, the fact that
reoffense?
Risk of reoffense. The factor 3, because he committed sex offenses against a prepubescent child, his risk and danger are enhanced.
I would agree with you, although you don't ever use words like paraphilia to describe someone who has sexual, maybe untreatable, but untreated sexual attraction to prepubescent children. That's why it's interesting to me, 22 years offense-free in the community, notwithstanding the nature of the crime. Now, maybe your position is anyone who has prepubescent victims is always at least a moderate risk, but then I'd like to hear something about paraphilias and how those work, and you don't give me that, right? I don't quite have...
Well, first of all, the hearing examiner doesn't have the ability to make any diagnosis of an individual. There was no diagnosis in the record saying that he suffers from a paraphilia.
Well, maybe the board should have found that out before asking for him to be a level 2 if he hasn't committed an offense for 22 years.
Well, again, this was a reclassification. He was asking to be reduced from 2000.
No, I understand, but the burden is still, it's not his burden to show how far it should be reduced, right? You remain to have the burden by clear and convincing evidence.
When
right?
is he due for a new reclassification?
It would be 2024. This is one actually moved quickly through the system. Again, the fact is that the board looks at all the factors. Even if you look at these studies from that go about offense-free time, they don't say it applies to every single sex offenders. It's an average. So there are going to be those who are higher than the average, those that are lower than the average. And that's what the hearing examiners are trying to determine at any given point. If an individual has enough offense-free time, is he still a higher risk than the
Do you
average
have data
person?
that shows that, that study that the board relied on in writing that factor?
Well, they relied on that in other, it wasn't the only study.
Okay, are there studies that show that the number is higher? For example, for people with extrafamilial victims, or people with prepubescent victims, or people who have had restraining orders against them? Because your brother is saying 1.05%. Why are you calling this moderate?
Because, again, there's other factors involved. And again, you look at the studies, and I've been reading these studies now, they have a new theory of desistance, where age and offense-free time combine into a point where there should be zero risk, except for individuals. And again, all these studies talk about the fact that there's certain individuals who are going to be outside of that. And the board, using its factors, are trying to find those individuals.
Does it explain why? What factors put you outside? I mean, I can't imagine that it's all covered by science yet, or by studies yet.
Well, that's the problem with the studies. They're not definitive. They're not conclusive. They basically talk about what they've discovered, but they also talk about the fact that more research is needed, that they need to, and they talk about the limitations in the studies.
But isn't that a problem with clear and convincing? Do you see what I mean? Like, I agree with you, but when it's fuzzy, tie goes to the runner, right?
I don't know that you use that analogy in this circumstance. I've used that analogy in court one time and got reprimanded, but you know, again, you got to look at the decision and decide, is it reasonable, is it fair, and did the hearing examiner do it properly? If he did, you got to give at least some weight towards the discretion of the hearing examiner. Again, if you disagree with that and you disagree with the hearing examiner's decision... How does that discretion fit with
clear and convincing evidence?
Excuse me?
How does that discretion... We're not reviewing for abuse of discretion. Mm-hmm. We have to find clear and convincing evidence.
Correct. And now, the hearing examiner felt, or at least found, believed he found clear and convincing evidence. If the court doesn't agree, you can obviously change that. But that was the hearing examiner's decision based on all the evidence that the hearing examiner took in, all the evidence that he considered. I think he did a very good job of making clear what weight he gave the factors.
In some cases, but yeah.
I think this was one of the better ones in that regard.
Do you think that there are people who, because of static factors, 22 years later, offense-free in the community, that the static factors alone put them at a moderate risk of reoffense, notwithstanding the study?
I would say no at this point, because I've had a couple of really, really bad cases in the past, one from the 80s where the individual was a serial pedophile, was a 3 for a long time, and recently was reclassified as a 1. So time in the community, positive strides in the community do play a factor in, and aging play a factor in reducing risk over time, and the board recognizes that. And I've had at least a couple, and the one I just told you about, but a couple of others that I was surprised that they were reduced, but they were reduced. So it does happen. In this individual's case, I think the discussion, the hearing examiner again pointed to that in 2015 there was an incident. It doesn't apply in factor 29 because it wasn't a conviction for either a sex offense or a non-violent offense, or a non-sexual violent offense, and that there was a restraining order as late as 2008. So those did factor into the hearing examiner's consideration.
What do we know about the 2008 restraining order?
Excuse me? Was
the 2008 restraining order violated? Was it obtained in 2008?
It was obtained in 2008, I believe. I think there was also 2 affidavits, one in 2006, one in 2003, by the same woman that claimed a physical abuse by this individual, if my memory serves me right. And if there's no further questions, I'd be more than happy to rest on my brief.
Thank you. Thank you, Paul.
Thank you very much.
Thank you.
The next case is 22P300 FERREIRA versus CHARLAND and another. Mr. Fonseca.
Good morning, Your Honors. Gabriel Fonseca for Appellant Laurel Charland. We are requesting this panel reverse the judgment from below because the housing court got two things wrong. First, the court should not have granted the landlord the right to reclaim the unit through eviction because when the court accepted the landlord's stipulation of improperly charging the tenant for water usage, Chapter 239, Section 8A mandates that the tenant wins the eviction case. Second, to the extent...
Well, that's an awful broad statement. So let's zero in on that if we could. I don't know that it mandates that the tenant wins, right? We've got to look at the cases, and I think the case that you both cite appropriately is Michael versus Nurse. And aren't there two things that have to happen in order for the tenant to gain possession?
Yes, Your Honor. So in Michael...
So on the second thing that the tenant has to prevail on, this is where you lost me in your brief. The damages on the counterclaim have to exceed the amount due the landlord, or if the damages are less than the amount due the landlord, the tenant pays to the court the amount due within 1 week, and that's Michael starting at 211. So I don't see how your client meets the second part of that test.
Well, two things. First, in Michael, for that second part that the court required, the damages from the claim or defense due the tenant exceed or equal to the amount due the landlord, or if less than that due the landlord, the tenant has a right to stay if the tenant pays. So the equals to...
But here, the tenant didn't owe anything, right?
But there's still a claim for possession. And so the monetary damages are actually secondary to the primary part of Section 8A, which is the prevailing under the claim. And so what Michael is saying is that even if there are damages that are due to the tenant still has an opportunity to stay. The tenant has to pay, but the right to possession maintains.
Well, the tenant would have to pay use and occupancy or rent, right? But that's not the question here. The tenant was up to date, as I understood it, on the rent.
Correct.
The landlord sent 2 checks with cover letter from counsel explaining what those were. We have those in the record. I'm not suggesting there was a stipulation or an accord and satisfaction, but at the time that you all were in the housing court, this was a no-fault eviction. The landlord had made the tenant whole times 3. I don't understand why your client gets possession.
Because Section 8A is about prevailing on the underlying claim. And the claim includes both the monetary and it turns it into a possessory interest.
But what did the tenant prevail on?
On the violation of the water statute.
Which we all agree was cured before the court hearing.
No, we did not agree that it was cured. We agreed that there was a payment tendered, but not that the claim was gone.
That's not what I said, though, right? You agree that the landlord made payments prior to the court date.
Made payment, yes.
And well, there were 2 payments. You don't dispute, they're in the record, right? There were 2 payments.
Correct.
Okay. And I know you're now trying to bootstrap in an attorney's fees question, and I don't know that that's properly preserved, but put that aside. If on day 1, your client was successful and got possession that day, on day 2, would she properly be evicted on a new summary process complaint?
I'm sorry, the second part of
your client wins this case.
Correct.
She gets possession, day 1. Next day, landlord files a no-fault supplementary process action. No defenses.
That's correct.
So what are we doing?
But that's the intended consequence.
I
that
agree,
Section
but
8
what the statute didn't contemplate was COVID-19. And with the moratorium, your client stayed in that property much longer than they would have otherwise, right? Because the landlord would have been in the next day to evict her. So I'm trying to figure out what this is really about.
What this is about is that.
I mean, the landlord was wrong. The landlord should not have been charging for water. And I don't think I'm going to hear from Brother Counsel that there's a defense to that. They paid the money, times 3. So really, at the end of the day, what are we doing? And Judge Field stayed it for 2 months to give your client a place to go.
So what this case comes down to, Your Honor, is that when the landlord filed the no-fault eviction case, the landlord got caught violating the law. And instead of accepting...
I agree.
Right.
So then what?
And instead of accepting the consequences, as the legislature intended by Section 8A, which is that the landlord should remedy the violation and then start a new case, that the tenant wins possession.
A new case was...
Michael has a part 2 that Judge Blake mentioned at the beginning. You don't just, you have to do more than prevail on the counterclaim, right? You have to still be owed money, and she was made whole times 3. So I don't see how you don't satisfy part 2 to get possession.
Because the statute also contemplates that there is no money due to either side. In the language itself, equals, and when the tenant is due money.
All right, so what's...
Wait.
No, go ahead.
Now, the SJC said the damages on the defense exceeds the amount due to the landlord. And you've agreed that has not occurred.
That the
water damages were paid and trebled. So there's nothing left that exceeds.
We agreed that the money paid was the amount that my client would be due under the claim. But the claim is two parts. It's not just monetary, it's also possessory.
I'm just saying what the SJC put the amount due to the landlord is part 2 of the test. And if you prevailed on part 1, you can't change the nature of the test they've created.
Did your client accept the tender?
No.
Did your client deposit it?
No. But that fact is not in the record, and so I want to be careful. But there is no evidence in the record of a canceled check. There's no evidence of acceptance, and that's plaintiff's burden to show. So there is actually nothing in the record that shows that there was an acceptance of the tender that would
So as a practical matter, you would have us remand the case with instructions that the following order enter. Judgment for your client in the amount of the water damage, whatever it is, the water damages, and either a fact finding will show that it's already been paid and so nothing is due, but there would be a judgment. And literally, 1 hour later, and I understand the SJC has said this, it seems like nonsense to me, but time-limited equitable remedy to get to possess your place for another day or whatever it is. The landlord can then, as soon as that judgment enters, walk into the clerk's office with a new complaint for summary process, to which there is no defense, and successfully evict your client. That's what you think should happen. How long would you say that would take from filing that new one to actual eviction?
It could take another 2 to 3 months at least.
And the
Depending,
judge
but
did enter judgment in this case in the amount of $0. That's at Supplemental Appendix 40, dated August 30th, 2021, and then you got a 2-month stay.
But the zero amount is the point, because that's where my
Part 2
client
under
should
the
have.
Michael test comes in, doesn't it?
Yes, but the statute, and the language in the statute and the language in Michael suggests that the monetary damages are secondary. They're not governing who gets possession. They're governing how the money is distributed.
Wait, I'm sorry, a judgment entered in your favor?
No, it did not.
Okay, I thought it did not.
No, it entered in the landlord's favor.
Okay.
Right, but the zero
So
amount
you're saying
should-
you want a judgment, and as I understand it, if the tender isn't a settlement, you would be entitled to a judgment in the amount of whatever the water thing is.
Right, because
Now, we're going to hear in a minute, probably, from your colleague, that, yeah, we already paid that, and not only did we pay it, it was accepted. Is that not true?
Opposing counsel may say that, but there is no evidence of acceptance in the record.
Well, how did the judge come up with 0 then?
So the judge assumed, I think what happened here is that the judge assumed some facts. What he did was asked for briefs on the legal issue regarding 8A, and he essentially viewed it as a summary judgment motion. And so there wasn't evidence taken. If you look at the record, there is no evidence of acceptance at all. And it's
Well, I'm going to
plaintiff's...
push back on that, because if you look at supplement, I agree there's no canceled checks in the record, but if you look back at supplemental 9, there's a letter from Attorney Farber, I believe to you, that says, here's a check representing a return of potential. I had requested a response from you well over a week ago, but just received your response today. As such, I'm sending you this check now. That suggests to me that there was, I can infer an acceptance there. You asked for something, and he sent it to you.
What he...
That's what I have in the record, right? I'm looking at a cold record. So when you say there's no canceled checks, true, but we do have correspondence between counsel that at least suggests something was asked of you, you responded, and then a check went out. What am I to make of that?
There's still no acceptance. It has to be an affirmative act of acceptance. And
Well, I mean, to
that's
Judge
not in the
Rubin's
record.
point, though, to Judge Rubin's point, we still have a judgment of $0, which implies that the tenant was made whole.
But even if it's 0, my client still has an interest in possession, and that's the point.
But if you
Not a legal
accepted
interest,
the
though.
tender, I mean, this is a pretty lousy case to bring, it seems to me. I mean, if you want to fight for the rights of someone to possess their property, I mean, there's already very, very tenant protective law here, right? But maybe you shouldn't accept the tender, right? I mean, obviously, tendering isn't settling. But when you accept a tender, what are you doing? Now, if you said to me, but I deposited the check, but I wrote on the back, this isn't in satisfaction of my claim, I don't know what this money is, it appears to be a gratuitous gift, and so I've kept it, well, okay. But if the tenant accepts the money, what's the consideration? What is it is it a gift? Is that how you view this? There's a lawyer's letter accompanying the check, right?
First, the lawyer's letter was not in the record at trial either. So it
It's
was
that
not...
supplemental record, right? 6 and 7.
Was it just submitted to us? It wasn't before the...
Correct.
Okay.
So there's nothing in the record actually at trial that demonstrates acceptance, affirmative acceptance. What I'm asking the court is that what I'm asking the court to do is grant judgment in my client's favor, because 8A is a uniquely...
In the amount of the tender.
In the amount of the tender following Henry v. Bizzuto management.
Yeah.
Because that case most
I
closely
agree, that's what it
resembles-
says.
Right.
So now there's a judgment in the amount of a tender. But if you've accepted the tender, can you execute on that judgment?
My point is that there's still a possessory interest.
There's
still
only a possessory interest if you're entitled to that judgment.
But not according to...
It's circular.
I think not according to Henry versus
But counsel, you
Bizzuto management.
didn't address, a case came out from the SJC after Michael called Davis versus Comerford. And there's a long discussion in there about the legislature's intent, again, protective of tenants, to increase the availability of counterclaims. But what is, as recently as 2019, the SJC says the tenant must meet certain preconditions to benefit from 8A. And one of those is the question I first asked you, which is the second part of Michael. The damages don't exceed it. So the tenant doesn't get the benefit here.
But Michael and the statute also says that when it's equal, that when the landlord and tenant are equal to each other in terms of the monies that might be due, the tenant still wins possession.
So if I gave you my pen and said, write the decision, this is what you want the appeals court to say, tenants get possession, plus how much dollars?
In this case, the tenant gets possession and
how much dollars?
And still an amount that was already tendered under Henry v. Bizzuto.
So are your clients due any money? How many dollars and cents do you say they're due? I'm guessing the answer is 0.
No, the amount that was tendered.
No, you have to say you're asking for the tendered amount, right? Or at least for the water damage one time.
Right.
That's what you want the judgment to say. I'm just a little concerned about what you can do with a judgment against someone who's already paid you. I don't understand that. I mean, I read Henry, and I get it. The tender doesn't moot the claim. There's no consideration for it. Now, I'd have to look at Henry again to see if they cashed the check or didn't. The fact that the judge found 0 damages suggests to me that maybe they did. The judge found that that your client cashed the check. And if your client cashed the check, then it seems like maybe it's different. I just don't. Do you see what I mean?
I understand the question. In Bizzuto, the tender was not accepted, and so I would assume that it was not cashed.
Okay. Here, I don't know, but I do see a 0 damages, so presumably they thought that your client had accepted it, I guess, the judge, I guess.
I think there's no evidence in the record to suggest that there was actual acceptance.
All we're talking about here is the sufficiency of the evidence to support that judgment of $0.
That's part of the question. That's part of the question, yes.
Your time is up. Thank you.
Okay.
Mr. Farber.
Thank you, Your Honors.
Good morning, Your Honors. Lawrence Farber on behalf of Cassandra FERREIRA. Before I get into what I was prepared to discuss, I want to address what this court has been addressing. And in the record, if you were to take a look at page of the record itself, it's page 39 of the appendix, but it's 1.10. The Judge Fields asked Attorney Fonseca, would you agree that your client has been made whole on the Wayne 8622 claim? And his response is, and this is Attorney Fonseca's, it appears that my client has been made whole, yes. But that is, there's an offer of settlement, but it does not mean was accepted for consideration. What goes on later on in this to indicate that they had received a check, they've never reserved any rights under that check, they didn't return the check, and that went on for a while before the trial.
But you're not claiming it was cashed. You're claiming they possessed the check. Is that right?
We don't know whether they cashed it or not.
Well, you would know.
What?
You would know.
Well, my client would know.
But you didn't put in any evidence of it being cashed.
Once he admitted, there was no need.
I read in Henry that a tender doesn't moot a claim because there's no consideration for it or a contract settling the matter. And as a consequence, it seems to me your brother may be correct that he's entitled to a judgment in the amount of whatever the damage is. Now then you maybe say to him, but you've got our check, and he says, okay, I'll deposit it, I don't know. Or maybe you got to write a new one because it's like 12 years ago now, whatever. But it seems to me that if a tender doesn't moot a counterclaim, then a judgment should have been entered in the amount of the tender. I know it seems idiotic, but I didn't write Henry, I didn't write Meikle, but that's what they say. And then you have to bring, for no apparent reason, a second summary process so that he may have the benefit of the time-limited equitable remedy.
If I can, Your Honor, two things. One, there was no rejection. There was no indication of rejection. There was no indication that they weren't accepting it. That's the difference.
This would be a pretty crummy case in which to make new law about what's a tender and what's a settlement, wouldn't it? Like this is going to matter to people with real cases who are tendering settlements in the millions of dollars.
I agree, Your Honor. The difference here is the amount that was tendered, and part of the reason why there was two checks that Justice Blake referred to is the first check was 3 times the amount. We then took a look at it and said, well, what's the worst possible damages even if someone was to view it in a way that is not anticipated? And that would be a breach of quiet enjoyment. So we then supplemented it to give more than actually would likely be given in the 186 section 22, where there is no breach of quiet enjoyment it talks about there. In our brief, we talk about how it doesn't really meet a breach of quiet enjoyment, but we decided to do it just the same. So the amount of the tender that was made and never rejected and never returned.
And if you could have gotten his client to sign a settlement agreement, we wouldn't be here. But it didn't work because it turns out his client had a good lawyer who understood about this time-limited equitable remedy that I never heard of before, and would rather have possession than some money, just like everyone else in the world.
The question, Your Honor, is a fewfold. One is that what's the public policy consideration that the courts have always looked at for resolving matters? We want things resolved because if every case went to trial, the court system would grind to a halt.
That's the part that just doesn't make sense to me. We have so much case law in the civil context about encouraging people to settle, but I don't even think we have to get to the question about whether or not it's moot. The question for me is, if there aren't damages, then how do they get possession? And do you think that Michael is the strongest argument for why they don't get possession?
Actually, there's a lot more. One of them, Your Honor, is the actual language of 239.8a. If you take a look at 239.8a in the important provision, the paragraph that starts, there shall be no recovery of possession under this chapter if an amount found by the court to be due the landlord equals or is less than the amount found to be due the tenant. There was no finding by the court here. There was no finding that there was money going to be due. There was, for that reason, it is moot by the time it came to trial.
It was even more explicit. He found that 0 was due.
He found that there was nothing due, and therefore it's 0, because if there's nothing due, there's nothing due. There was no actual hearing in the sense of that on that claim, because he said it's moot. It's already been resolved. There's nothing for me to rule on at this point. That's the difference between his request for possession and what's required under 239.8a. 8a contemplated, and I know this is somewhat dicta, but it contemplated large landlords who are not doing their jobs, who are giving substandard tenancies. We want to penalize them. And that is talked about in Hodge v. Klug, a case which has very similar situation here, where someone was trying to get a very small landlord. My client, this is their only property. She's trying to move into her property after her relationship with her boyfriend breaks down.
But that can't help us. We have to figure out what the rule is. I get, the whole thing seems unjust, but I didn't write Meckley and I didn't write Henry.
No, but Your Honor, if I can, you can also look at, we have cited the security deposit, and Attorney Fonseca admitted that by tendering a security deposit return, it moots it. Nowhere in those cases does it say, nor does it, by the way, in the statute. It just says there's single damages if you return it within 30 days, and it's 3 times the amount if you don't return it in 30 days.
But that's a different statute that has a specified provision for returning the amount.
It doesn't actually have a saying that it moots the claim. But then Kastenholz does, and so does Tyler v. Boudre. Both of those kind of say, well, if you cure it, it's done. Well, that's the same issue here. If you cure it, it's done.
Well, but no, interestingly, the statute talks about the tenant's right to cure if they owe rent, but it doesn't address the landlord's right to cure.
But in this instance, because it was done before trial, there was nothing before the trial for the court to try. The whole purpose of 239.8a is where there is a dispute on how much should be withheld, what are the tenant's damages. Here, there was no dispute on the damages. They were cured by giving the tenant the maximum amount that they could possibly have won, not the minimum.
brother counsel suggested that he treated this as a Rule 56, but this was a trial. Your client testified and was cross-examined, and the tenant testified and was cross-examined.
Actually, it didn't really go that way. What happened is, at the beginning of the trial, we kind of presented in oral arguments where the case was at, and then the judge kind of said, well, I'm finding that it's no longer a part of the case. So it was all done basically most of it was done by representation.
Your client did testify, right?
She did when the judge then asked for certain clarifications.
Okay. Did the tenant testify?
I am having a hard time remembering. I did reread it. I believe she testified on the 239 9 stay of execution issue only.
If Henry applies and the tender is just a tender, then shouldn't a judgment in the amount of the water, the damages related to the water charge, have entered? And then wouldn't we have an amount due to the landlord being less than the amount found due to the tenant by whatever small amount this is? And wouldn't we be in the exact situation of Miko, where even though it's maybe wrong and certainly a pain, you get the judgment, you pay as a result of the judgment, not the tender that they didn't accept, and then you bring your second action, and it would have been a hell of a lot faster than this appeal.
Two very quick things, Your Honor, on that. One is the amount of the judgment almost is certain, if a judgment was to have entered, be less than what was tendered. So it creates a totally different...
That's fine, but it's an amount. It's
but
the
I'm just saying
proper
that.
amount.
So the point would be that they have received an amount of 3 times the...
You can't force people to accept your tender.
But they have to reject it. They have to...
No, I don't think that's right. Does Henry say they have to reject it, or that it's not, a tender isn't a settlement?
The whole point of, for example, Rule 68 is exactly that, Your Honor. It's also the whole point of 93A when you send a demand letter. It's to cause the other side to say, yes, I'm accepting it, no, I'm not accepting it.
We don't
Here, they
have-
kind of
we
stayed
don't-
silent, but held on to the money.
Where is the statute, like 93A, that requires them to accept your tender? Because I don't think there is one. I don't think you can make someone accept a tender by making it really big. People would go around all the time. I've been dying to build this bridge, and this holdout won't let me here. This is 5 times the value of your house. Take it.
But if they don't reject it, if they reject it, I agree with you, Your Honor. The issue here is, did they give any indication until the time of trial that they weren't accepting this? They held on to it for months.
They didn't deposit it. They held on to a check.
But they didn't tell us, hey, we're reserving our rights, we're proceeding on this. The second thing, Your Honor, and this is somewhat ancillary, but you should be aware, we did file another summary process.
And he stayed it, right, Judge?
And he
Fields?
stated, based on this case, even though we said, Your Honor, how is this case going to affect the second case?
So
And
is the
my
tenant
client is
still in-
still not living in our
The
house.
tenant still in the property?
As of this date, yes.
So if we ordered, I'm trying to think the fastest way from A to B, and we haven't deliberated about the case. I don't know how it's coming out, and it's not clear remotely from the questions that anyone agrees with me except myself. But if we said a judgment should have entered because they didn't accept the tender, and the judgment should have been not for the 3 times amount, not for the quiet enjoyment amount. It should have been for whatever it is, $62 or whatever. I have no idea, some tiny amount of money. And we instruct that that be entered, and that as a consequence, the stay be lifted on the second action. How long would it take you in the second action to get these tenants out?
It would take finding a trial date, which is probably about almost a month.
And if we issued our rescript forthwith, so that the day we issue our order, all this stuff happens, you think in a month, maybe, you could have your property back after
Yes.
paying them the $62 or whatever?
There's 2 factors. One is you got to win the case, which we would, because there would be no longer counterclaims. But then the issue is the 10-day appeal period and getting the sheriff. And unfortunately, there is only one bonded mover in all of Western Mass, and therefore that adds another month. But yes, it would be about somewhere between 6 weeks to 2 months, likely.
I couldn't find any cases directly on point, but I did find a number of housing court decisions by the same judge that has done this same thing. Not that it has any precedent or is this what's happening in the housing court on these kinds of cases?
Unfortunately, frequently, yes. I do a very large practice in the housing court, several hundred a year, probably 400 or 500.
And you see this fact pattern with proffered tenders and no acceptance and no rejection? And
No, this is the first one I've had on that. Almost always it's accepted and it's resolved, or they say not enough and send me some sort of either communication, either email or return the check or something saying that we're rejecting
But does the tenant get possession in those cases?
I have to say the vast majority of them resolve.
you settle
when
them,
that
but
happens.
maybe you settle them and say you can stay for 2 months, but then get out, and it's going to be longer than the second summary process anyway,
Right.
so maybe they take it or something like that.
Yes. No, and in this kind of case, as I said, the frustrating part, and again, we're getting into the second half, is the Hodge v. Klug issue, which was in Hodge v. Klug, the concurring opinion was voicing the frustration of a small landlord being trying to get repossession for a personal reason, and it just being delayed on potentially technical grounds, which we disagree with Meade in this instance, but yes, that's the frustration. If there's any other question, I'm more than glad to go through it, but I think Your Honors understand the issues that are involved.
Thank you. Thank you both. Our last case is 22P585, DeSantis versus QUIRK Cars Incorporated. Mr. Feeney.
Your Honor, may it please the Court. Thomas Feeney, appearing on behalf of John DeSantis, plaintiff appellant. With me for Mr. DeSantis is Paul Cacciati at table. If I can begin briefly, a short synopsis is helpful, and it will be short. Plaintiff John DeSantis Plaintiff John DeSantis was a car salesman working for defendant QUIRK Cars. John Molnar was a supervisor hired by QUIRK despite a long criminal history record. It is indisputable that on a particular day in 2016, Molnar attacked DeSantis without provocation. There's a video in the record that clearly shows it. It's also indisputable that at the probable cause hearing designed to hold Mr. Molnar responsible, the video was not produced, and affidavits by other employees who were present were produced, but those affidavits were blatantly false when you look at the video and then you look at the affidavit.
I have a completely different question. We've seen the video, we've read the briefs. This is a suit for an intentional tort, right?
Yes.
And it's within this, happened during the employment relationship, right?
Yes.
So why is Anzalone not the end of this case?
Because as the Supreme Court in Doe versus Purity Supreme and other cases have found, an exception to the exclusivity provision is found in the vicarious liability statute. And Judge Lang, who issued the order on summary judgment in this case, I think that he misread Doe versus Purity, and I'm sure the court has read it, but I just want to emphasize that in that case, which was a sexual abuse case, where this court has found in multiple cases where that could never be in furtherance of the employer's interest. Because there's a difference here. It's not just in the course of employment, but the vicarious liability standard brings in that fact of whether or not it was done in the employer's interest, and that's what Judge Fahey ruled upon when she denied the initial motion to.
But that didn't Doe make the same argument, and that the SJC didn't buy it there?
Because that, and once again, I was just going to get to that, Your Honor, because the ruling in Doe, when they dismissed the false imprisonment claim, is here, the assistant store manager's conduct as alleged was not motivated by a purpose to serve the employer.
And therefore, workers' comp wasn't exclusive. But in your, I just don't understand how you're reading it exactly backwards, it seems to me. If it's in furtherance of the employer's interests, although I wouldn't have written a law this way, because what do I care? Seems like intentional torts aren't really accidents at the office, but these are old cases. Then this is what they say. If it's in furtherance, your position is this was in furtherance of the employer's interests. And there are flat holdings, like 9 of them, saying if it's in the scope of employment, in furtherance of the employer's interests, the exclusive remedy for intentional torts is the workers' comp statute. Now, maybe you should go to the SJC and ask them to change that on public policy grounds. I understand that argument. But Purity Supreme says the opposite of what you're saying. It says when it's not in furtherance, it may be actionable against, I think, against the tortfeasor, not against the employer. But still, your point is this is in furtherance. It just seems like it's been flatly held repeatedly.
And I would respectfully disagree in reading Purity Supreme, because they specifically spoke about the reason why they apply the exclusivity provision in Purity Supreme to that false imprisonment case was precisely because there was no evidence.
They don't apply it to the sexual abuse claim, right? They say that wasn't in furtherance, you can sue the tortfeasor, right?
All I'm saying is that they applied, once again, I apologize, they applied the exclusivity provision both to the sexual abuse claims and the false imprisonment claims precisely because there was no, that the tortfeasor, the perpetrator, was acting on behalf of the employer's interest, which is a different analysis than whether or not it was in the course and scope of the employment. It's an additional fact, and that's why both Judge Fahey and the court in Purity Supreme recognize that the vicarious liability is a live doctrine in this jurisdiction, just as it is in other jurisdictions, and I've listed probably 8 of them.
Mr. Smith is going to tell us that it's the nature of the injury and not the identity of the perpetrator that controls here, which seems to make a lot of sense to me if it's in the course of employment, as the point I think Justice Rubin was trying to illustrate. And Doe seems to say the same thing.
And once again, as I read it, it's not the identity vel non of the perpetrator. It's what that person had in mind. Was he acting in his employer's interest, whether they're
I thought everyone agreed here that what's his name, Molnar, was acting in the scope of his employment.
Without question. But the vicarious liability standards accepts that and says that an exception is created when the injuries occur because that supervisory employee was acting in his employer's interest, not just within the scope of the employment. And the ruling is in detail in the Jett case from Connecticut addresses that very point. Now, they have Connecticut has a different standard for vicarious liability. So I'm not saying that this court should adopt Connecticut's standard, but they could. But what I'm saying is that Massachusetts has a well-established standard for vicarious liability, and it provides an exception And there are, either the exception exists now, or this court should find that as a matter of public policy, like other courts in the country, that an exception should exist.
I think that's a matter for the legislature. I mean, this law has existed as it is for a long time, and they've chosen not to narrow it in the way you're asking us to.
And with the other cases I've cited, I respectfully put forth to this court that that opinion in Doe versus Purity Supreme specifically recognizes, like, why bring it up otherwise? Like, why even mention vicarious liability in this context if it wasn't an exception? And why do they say, well, it doesn't apply because no evidence was put forward that that person was acting in the employer's interest? That's why it applies, because the Supreme Court raised it as a viable doctrine to create an exception. And then they kicked it out precisely because they didn't have the facts in Doe that we have in this case. I mean, not only was it alleged, and actually indisputably alleged, that Molnar was acting, basically because he thought that Sansa was interfering with its work and acting in the employer's interest. But after that, the employer gets involved and presumably on summary judgment standards, coordinates the submission of affidavits by the other employees to say precisely the opposite of what the video shows. So this is an employer action. And to allow, I just cite to, as I said, the cases, and I've quoted them, but Horwitz on workers' compensation says, it would be against sound reason to allow the employer deliberately to batter his helper and then compel the worker to accept moderate workman's compensation benefits either from its insurance carrier or from himself as self-insurer. So there is a public policy here as well to buttress what the Supreme Court held in Purity Supreme. And that's what I keep coming back to, because I believe Judge Lang has misread Purity, but it says it right in the case. They bring up vicarious liability. Why bring it up if it's not an exception?
Well, Doe does say injuries resulting from physical assaults by one employee on another are compensable exclusively under the Workers' Compensation Act. That's a quote from Doe.
No question about it. But it doesn't talk about what Doe goes on to talk about. Well, intentional torts. However, if those intentional torts were perpetrated in the employer's interest, then the doctrine of vicarious liability applies. And that's the distinction. So if you look at those...
Are you drawing a difference between the employer's interest and the scope of employment?
Yes, very much so, Your Honor.
Explain that.
If it's in the course and scope of employment, it's very broad in this jurisdiction and in most jurisdictions, right? As long as you're working during working times on the premises, it's within the scope of employment. Even if you're driving a truck and you're doing it for the employer, it's within the scope of employment. That's a very broad statement.
Okay, but I'm looking at Green versus Wyman Gordon, which was decided the same day as Doe v. Purity Supreme, and which is cited by it as the rule that's about exclusivity. An employer may be vicariously liable for emotional distress intentionally inflicted by one employee on another. However, we need not decide whether the employer was either directly or vicariously liable, since in either case, the injuries would be compensable under the Workers' Compensation Act. Doesn't that say even things for which they would be vicariously liable, if they are compensable under workers' comp, it is exclusive? Is that not what Green v. Wyman Gordon says?
In a similar nature, though, that case also only dealt with sexual harassment.
Well, that's something that's a stronger case than your case. Who would imagine that sexual harassment would be compensable under workers' comp rather than under a direct tort, right?
Except that, as I was making that distinction between in the course and scope of employment, which is very broad, But then, and as this court has found in multiple cases, including Foley and Doe, that sexual harassment, sexual assault is never in the employer's interest. So therefore, the exclusivity provision and the vicarious liability doctrine does never come into play. So it's never an issue there. But the fact that in Doe versus Puri Supreme that they took the effort to discuss it in detail, that, hey, but for the fact that there was no evidence showing that these intentional acts that occurred in the course and scope of employment, there was no evidence that they were also in the employer's interest, then the vicarious liability exception doesn't apply, because otherwise it's meaningless what they say in Doe with regard to that vicarious liability section. It renders it completely meaningless. And, you know, and there are other issues raised. So, for example, they cite, well, he had a chance when he first began his employment to waive out of the exclusivity provision. One, he was never given notice of that opportunity, especially in the employment context. You would expect that that would be a requirement. Two, what employee is going to contemplate waiving out of a system from damages that never could be reasonably contemplated? So that is another public policy reason why his failure to sign, you know, a waiver of that shouldn't apply in this case.
Was there a criminal case involving this assault?
There was, as I explained a little bit, there was a probable cause hearing against Mr. Molnar. And at that probable cause hearing, the video was never produced, and those 3 or 4 affidavits.
Explain that, I think, when I cut you off. So how does that impact the claim at all, whether or not there is a prosecution?
No, but it does impact this court's decision with regard to there is indisputable evidence that the employer, not only before the fact in negligent hiring, negligent supervision, but they tried to cover it up. They coordinated these affidavits to show. And I see my
I'm sorry, your time is up. Thank you, Mr. Feeney.
Thank you.
Mr. Smith.
Good afternoon. May it please the court, Ryan Smith for the defendants' appellees. Just a few comments, Your Honors, I'd just like to make. The Doe language cited by my brother about the vicarious liability, there's a very clear distinction. The court discusses, you know, all the elements that, you know, of related to sexual assault that involve personal injury. What it says, these are personal injury claims. The court says false imprisonment is not a personal injury claim. That is the only context in which they speak of vicarious liability. The Fels-Akers case, which is cited in plaintiff's brief, they excuse me, there is discussion about I think that's the main.
Wait, I'm sorry. So your position is that a false imprisonment claim within the scope of employment, in furtherance of the employer's interest, is not barred by the exclusivity provision because it is not a personal injury claim. Is that what you're saying?
That's how I read Purity Supreme.
So Purity Supreme, you agree with your brother, holds that an intentional tort, in that case, false imprisonment, an intentional tort in the scope of employment, in furtherance of the employer's claim, is not barred. So that the blanket statement in Anzalone, or suggestion in Anzalone, that intentional torts in the furtherance of an employer's interests undertaken in the scope of employment, that those are barred, there's now an exception that Purity Supreme has created. And you're saying if we dig through Purity Supreme to try to figure out what the heck is going on in that case, that will conclude that false imprisonment, why would that be any different from a punch in the face? I'm now lost.
I can't explain why the court decided that that was not a personal injury, but that's what they're relying on, is that that they viewed as not as personal injury. It's not.
But what does that have to do with the exclusivity claim? Either it's an intentional tort in furtherance or it's not. Well, who cares if it's personal injury? What kind of injury is it? Personal injury sounds worse to me, but all right.
I'm not sure. I'm not sure. I understand that, Your Honor, but why they make that distinction? But this is clearly within what is contemplated everywhere above that line that they mentioned.
Well, clearly now seems a little blurrier than it did to me coming in.
Okay.
So what could Mr. DeSantis have done? What was his remedy?
To be compensated under the Workers' Compensation Act.
And that's it?
That's what the exclusivity provision says in Section 24. And, I'd like to just note, Your Honor, the Saab case, which I cited in the brief, SJC said it doesn't matter whether he sought the compensation. It's not relevant to the inquiry whether the claim is barred. If the injury is compensable under the Workers' Compensation Act, there's no relief in tort.
He could have sued Molnar individually, right?
I don't believe so, Your Honor. I believe, in
Okay.
fact, there's an employee is immune from tort liability under the Act, provided his or her activity resulted in another's
Within the scope.
employer
Okay.
injury, and that's Mulford versus Mangano. I can give you the site if you want. Okay.
Is the false imprisonment not compensable under workers' comp?
That appears to be the conclusion that they reach in Doe, but it.
Why wouldn't it be?
But they don't. I don't know, Your Honor. I think it's an injury as well, but but false imprisonment has not been alleged in this case.
Okay, but we need to know what the principle is so we can apply the right principle. And I don't understand why we're not applying the false imprisonment principle to the punch in the face.
Your Honor, I mean, Doe is clear that if there's an injury, that in the course of the employment, the nature of the injury, the mechanism are relevant. I don't understand why they chose false imprisonment to not be an injury, but I think it's pretty clear on the face of Doe that this is within the ambit of what's barred.
Is there anything else you'd like to tell us?
I'm sorry, Your Honor?
Is there anything else you'd like to tell us?
No, Your Honor, thank you.
Okay, thank you. Thank you all. With that, I'd like to thank our court staff, our court officers, our clerk's office, our excellent timekeeper, my colleagues, and we will stand in recess.